Okay. Perfect. Well, hello to everyone from me. My name is Mirko Kikkamägi. I'm an attorney at the TGS Baltic, and well, I've been involved with product turn for some time. And today, from my part, I would like to give you a slightly better understanding what are options, how to use options as founders to attract talent, to maintain them, to align their interests, and at the same time to be able to really understand the implications of using options. And with me, I have my colleague Maris with me.
Hi. Who
will, in the second part, discuss and explain a little bit about the differences in various types of employment-related relationships, because sometimes for a startup it might make sense to have employment relationship. Sometimes you just need service providers, and there are certain differences one should take into account when dealing with different type of service providers from the point of startup. Now, and let's jump into the first part of this webinar. Let's see some. Okay, just in terms of very general overview, I understand that you have been introduced the concept of option pool in one of the previous presentations, and here I would first want to jump into the idea that why even to use options and what they really are, because in their essence, option is a company's promise and employees' right to become a shareholder in the future. So it means that this doesn't, the shareholding or equity ownership doesn't happen right now, for example, tomorrow, but rather at some specific designated time in the future. And why we are even discussing this topic is because of their nature. They have become a vital tools for startups when attracting talent especially at early stages, when maybe you have next to no money whatsoever, but you need to keep people motivated, and of course at later stages as well, to ensure that you can still attract the top talent that you need. And that because it is a simple reality that startups usually do not have sufficient funds to compensate the talent they want to attract. Therefore, options can be used as, so to say, bridge between what the company can pay them, if at all, and what these employees whom you want to engage for your startup actually deserve. The second, so this is just in simplest terms, simple way of compensation. Secondly, it has the massive benefit, and that it is one of the most important reasons I would say why founders should use options, is that it actually aligns the interests, because employees and owners' interests may differ, because some take a more broad, long-term view, also knowing that if there are mistakes, that it will have financial repercussions. At the same time, of course, if something is done very well, the rewards will be shared. Therefore, it aligns the interests, and I would say always when someone has their own skin in the game, that they are more motivated because they know that they will feel the impact. And of course, it has due to the nature of the options and related tax implications, so which I will cover at the end of the presentation. The way, at least in Estonia and the majority of the world, how options have been set up is that you have to be employed by the company at least 3 years before the true value of options can be realized, meaning the tax benefits and the reason why companies issue them. Therefore, it
Sorry.
in Estonia or in Latvia as well?
But it's the rule in Estonia, but this is it's mainly in Latvia, Lithuania, it's in US, it's in the match. It is worldwide. It is standard, because of course for specific countries this needs to be checked, but it is more or less the rule for the simple reason that some aspects have been so to say agreed upon, and it's for the competitive purpose, because and this is the, so to say, worldwide market practice, which doesn't mean that in the different jurisdictions this is 100% the case, but the assumption can be made that there will be definitely some time period. It can be slightly shorter, it can be longer, but I would say majority of the times it is 3 years. In any event, sufficiently long periods of time to ensure that the employees have to take the long-term view. Once you as a founder have well established for yourself the benefits of the options, which are mainly that it's about part of compensation. It ensures that well, employees have skin in the game and they are, well, at least in theory engaged in long term. You have to then come up, well, you have to focus on the idea that, okay, I know I want to use options, but how much options do I want to have, and how I'm going to provide the underlying shares for such options. And usually it's the first question is, how large should be the option pool, meaning the pool of these options you're going to share among employees and potential contributors. And the market practice in Estonia, and same worldwide, it ranges from 10 to 15%. It can be smaller, it can be larger. Of course, it depends on the specific company. But like, if you establish some option pool within 10 to 15%, no one can say that, oh, you did it wrong, because so this is a rule of thumb. If you have that 10 to 15%, that you're in the right ballpark. Secondly, then once you have established how much options you want to share, is how you're going to set up the option pool. And for that, there are three ways. One, the shares which will be shared by way of issuing options with employees will be founders' own shares. For example, if you have two co-founders, in the beginning, both of you own 50-50, and you decide, let's have a 10% option pool, you could say that each co-founder has 45% shares, and 10% of the shares have been, so to say, allocated or already planned to be issued to the employees. And then if you want to issue more options, then again, both co-founders' share will be reduced, meaning that the options will be handed out of founders' own shares. Sometimes either through, you can have first maybe 3 co-founders. Let's say you have 45%, or even 40%, 40%, and 20%. You have 3 co-founders, but one decides that I'm not really going to be involved in this company, and sells its shares not to the other 2 co-owners or founders, but rather the company itself. In such case, it's considered that the company owns its own shares. They are called treasury shares, and these can be used to well, allow the employees to exercise the options, meaning that if it's time to exercise options, the founder's share will remain to be 40-40, and rather this 10% option pool will be, so to say, paid out of the 20% of shares held by the company itself. And
I have a question. So it means that in that time when you're, making dividing the shares, or you have to put aside like real capital in case you need to exercise the options. So it is how to say, is it that you initially already have to, show in the register that you have option pool or somehow, or it is like just legal thing?
Yeah,
I agree.
See the point. Because short answer, no. And this is the third issue, new shares. Of course, even if upon this number 1 or 2, if you have planned to have an option pool, this is not something you will record in registry, because in the registry you will only have shares that have been allocated to specific persons. The option pool, it is contractual agreement. It's like internal thing that you have agreed to do that, and then you will issue the shares in the future. And one option is that you can agree that these shares will not be founder shares, because in the simplest example that we have 2 co-founders, each own 50%, and it's let's say Estonian standard company which has share capital of 2,500 euros, then both shareholders will maintain their 1,050 euros shareholding, but you agree that in 3 years' time we will issue new shares for the value of 10%, meaning that then let's say 250 euros worth of new shares will be issued, and the share capital will be then 2,750, meaning that the co-founders who still have 1,250%, which used to be 50%, by way of issuing new shares, they will be so-called diluted, because their shareholding is not worth 50%, but rather something close to, I think, 45%. Ultimately, their share, but they will still have the same amount, but because the number of shares in the share capital is greater, then this will be somewhat diluted. Yes, Kirka.
Yes, I'm just wondering, because when you increase the capital in the registry, then it comes from some actual like paid amount, right? So how or where does the like literal money come from?
Okay, because once because this is something that actually has to be paid into. I will cover that in later stages, where covering the option exercise price. But in very general terms, in order for the option holder to exercise the options, they probably need to pay some the nominal value of the shares. That's the most common approach. It has certain tax benefits from the company point as well. And you can either have just new shares issued, for example, some founder who will hold them, or in 3 years' time, let's say you have 5 employees, and each of the, and in our example, we had this option pool of 250 euros. Then in 3 years' time from now, you will increase the share capital by 250 euros, and each this employee, each of 5 employees, each will pay 50 euros, and this will be paid to the company's account. But there are differences how to pay the share capital, increase the share capital. But for capital increase, monetary payment has to be made, and at the same time, to exercise the options, it is recommended that some certain payments are made. But this doesn't have to be this way. But these are somewhat separate matters, because to maybe from option holders' point of view, you don't really care how the company exercises or increases the number of shares they are going to issue to you. You want to see that the option agreement you sign with the company has some regulation on that. But for example, in the Estonian case, as long as you are using Startup Estonia's template documentation, it includes this regulation. So I would say this is, in practical terms, this is not really a worry. because how the practice is that for options you usually have to pay the nominal value, and at the same, and this will be used also to pay for the increased share capital. Yes, Kirke.
Sorry, maybe it's a topic for later, but I was just thinking, because I increased my company's value by like having a new asset. So it was literally my laptop. So what happens to the shares then when you get like the asset increases the shares?
Sorry, I had some issues with this topic. Can you please repeat?
I mean, that's it doesn't have to be like money payments, right? In Estonia, it can be also an asset that you take into the assets, and that increases the shares as well. So what happens in this case?
Because I would say these are slightly different issues. I would say from option holder point of view, you don't really care how these shares are issued as long as they are transferred to you. And by standard issuance of options, you are not for options. If you're an employee, I've never seen that you can pay for them with non-monetary value, and that this is you have to pay monetary value, and probably in that case, then the company has its own treasury shares or founder shares. But if new shares are issued for a monetary value, then it's possible that you subscribe to such shares upon share increase. But it's important to keep in mind that these they are somewhat connected, but one does exercise of options doesn't automatically is not tied to the share capital increase aspect. So to say, it is possible to increase the share capital by non-monetary ways, but this goes a little bit into a separate matter, and it's in more of corporate law, but this is company's decision. Ultimately, it is company's decision how it ensures that it has sufficient amount of shares that the option holders can subscribe to, and then just the option holder upon exercising the shares. And I will come back specifically in the second part on the how options are exercised, and that there are a lot of aspects that need to be taken into account. But yeah, the way how share capital is increased, it doesn't really determine whether, if, and how options can be exercised. They are related, but they are so not to say critical matters that and most importantly, from option holders' point of view, I would say that literally I don't care in the sense that you don't care how your, for example, employer gets money on the bank account as long as they pay you the monthly salary. Is it by way of raising capital from investors or selling some goods? It's roughly the same situation, that you just want to know that there is the sufficient amount of money in company's bank account to pay your salary, or in our case, that the company has either sufficient shares or agreements in place which allow them to issue shares to you. But then, if it made sense, but I will cover this topic a little bit more, and if it still remains a bit unclear, later we can come back to that.
Okay.
Yes.
I just said thanks.
Yeah. Sorry. Okay, because once options are issued, it's one of the most talked about point is option vesting, which relates to the principle how and when the employee receives the right to obtain the shares. It means in like, well, lay terms, it means just how you, although you have the option agreement, how do you actually earn the right to really have those shares? And there are, well, two different types of vesting. One is time-based, and this is the most common. This is what you would see in 99% of times. It's just by each month you're employed by the company, the option holder earns at 1/36 of the underlying shares. So if standard option vesting is either 3 or 4 years, let's keep it simple, have 3. In our well, practical example, after 1 year you have, and if you were issued, let's say 66 euros worth of shares, then after 1 year you will have earned 22 euros worth of shares. By the end of second year, 44 euros worth of shares, and by the end of third year, the whole total amount 66 euros. There can be performance-based options, but I would say that these are only, to keep it simple for you, wouldn't recommend using them. They seem very good. Of course you only get options if you actually perform, but this is usually for very key employees, because the main issue is how you're able to actually, who will determine if you have actually performed. And of course you can say that, oh, I as the co-founder, but that there are two practical reasons I would not suggest, at least at the very early stage, to use these. Especially if you're not very well, if you're not very familiar or experienced with options, is first, even considering the pace of startup companies, how things can change, what seems to be priority at one quarter can change for the second quarter. So it is very hard to have objective actually understanding what were the targets, what you had to achieve. And you could say that, oh, then I will check whether that suits to me. But the most practical example is that for a very early startup, I would say that this is where the market would fix in the sense that, yeah, your eagerness to use performance-based options. Personally, if I were to join a startup at this stage, I wouldn't just agree for the performance-based vesting, because it has so much, it's so subjective. And from founder's point of view, yeah, it's a perfect thing, assuming you can come up with objective criteria. And I've tried to go, I've advised some companies who wanted to use them, and that, because you can't really come up with something that you could say that from other employees or standard startup employees' point of view seems fair, because it's actually in practice very, very complicated. Therefore, for the sake of simplicity and well, actually being able to manage, and at the same time, because if the vesting doesn't work for potential employees and you can't use options, the whole point falls away, that if you're trying to be very smart, but the outcome is that you won't have employees. Therefore, as the Startup Estonia templates are based on time-based vesting, keep it just simple until you're maybe more familiar with the options, have seen how to suit your company, your employees, and then maybe you can tweak that. Now, of course, something already today, if you're planning to, well, issue options, you actually have to think about, well, the main thing that already some questions covered in the beginning, it's exercising options, because no one really cares about options for other than for the reasons that at one point options turn into shares. And then in the beginning, you have to think through, one of the most vital things is how much do you actually have to pay to turn your option into shares. And the markets, to keep it simple, the market standard in Estonia worldwide usually is the nominal value of the shares, at least especially for Estonian context, because otherwise it will have also some tax implications for the company. So from the point of view, you all being startup founders, I would say for option agreements you enter into, agree upfront that the strike price is the nominal value of shares. So if someone is, in our example, those 5 employees, each should get 50 euros worth of shares, well, agree upfront that they must pay 50 euros. And this keeps everything quite simple from the company's point of view, because you don't want to, because even if you want to give them this free, you will create yourself some administrative and accounting headache. Of course, you have to take into account maybe the issuance of shares, because I will at the moment even skip this Nasdaq point, but you have to take into account also and agree upfront with the option holder that once you actually exercise the option and this turns into shares, that the option holder needs to join with the existing shareholders agreement, because you want them to be regulated by the same agreements you as founders are bound, just to ensure that they can, for the simplest reason, that they vote as they have to, and that they follow certain share transfer aspects. I understand that Kati has covered the shareholders agreement in broad terms. So this is, you don't want any single shareholder being out there who is not covered with shareholders agreement, because immediately that would happen. That would potentially create a lot of headache. Some things you need to take into account is, for example, spouse's consent, because if you have a joint matrimonial property registration, and you do want to control whether the options can be transferred after they're exercised or before them being exercised, because you don't want the situation that, for example, I'm the option holder, I work in your company, but for some reason my colleague Maris will get the shares, because you might not even know her, and then you have, so to say, outsider among the pool of shareholders who are familiar with the company. Thus far, everything has been mainly focused that options, they have benefits, they save a lot of money for founders in terms of salary payments, because they can be used as replacement, but it's not always going to be perfect, nice, and very upfront positive that all employees will stay with you for 3 years, then they will exercise their shares, and everyone will be extremely happy, as there will be a multi-million exit, and everyone will live a nice life. Therefore, it is important to anticipate conflicts, and usually all option agreements have some sort of regulation on that. And in very broad terms, it has regulation when you're a bad leaver, for bad leaver, if you're, for example, fired for a cause, you don't fulfill your tasks, or what can also be considered as a bad leaver, if you just decide that I don't want to work in this company no more, you just voluntarily resign, maybe join a competitor, maybe even not, and then you will be treated as bad leaver. And usually in such situation, what happens is that you usually, both the unvested shares, okay, let's have a practical example, because we had 3 years option agreement. After 2 years, you decide that I will join a competitor. In this case, you're a bad leaver. You have vested 2/3 of your shares, and 1/3 you haven't even vested, because you have only worked for 2 years. These unvested shares, you will lose absolutely. And in most cases, even the shares you have vested during the 2 years time, you still have to give them up. Maybe you get some sort of compensation. It depends what's agreed. Maybe it's the nominal value, maybe it's some bare minimum. Sometimes you get nothing. However, if you're a good leaver, for example, you have some, there are very rare cases where an actual person is automatically good leaver. Rather, this is something the company can decide. For example, even if you leave and you don't go to a competitor, the shareholders can say that, yeah, but you still contributed to the company and we can consider you as a good leaver. And in such case, yes, you will lose this unvested part, but for this 2/3 of the shares, let's say in our example of 66 euros, this 44 euros worth of shares that have been vested, then usually you can transfer these to the company for, let's say, a fair market value. The whole regulation is contained, for example, in the Startup Estonia's option agreements. And of course, from here, it's evident that it's always, as an employee, you want to be a good leaver. You never want to be a bad leaver, because in simplest term, if you're a bad leaver, you usually get next to nothing. As a good leaver, you get quite a bit. Now, of course, the problem part is that there are not too many options where you are a good leaver. However, some companies have, and you have the freedom to regulate that even if you voluntarily resign, let's say after a year or two, you're still good leaver unless you join a competitor. No, because which makes sense that it maybe just take everything away from someone who has contributed for 2 years seems a bit harsh. Of course, if they are going to join your competitor, which is absolutely risky from the founder's point of view, then you don't want to really compensate them. And because and usually the employee with option agreements, they contain the relevant regulation that what happens, what will be the specific price. And this is something in each time when establishing what type of options you issue, you should keep in mind. But for example, price of the options, call options, meaning the company's right to then demand that well, transfer back options to us, or what even happens that today we have this company that has share capital 2,500 euros, as I was saying in the beginning. But within 2 years' time, it could be that the company has increased the share capital fourfold, and now it's 10,000 euros. But you were initially promised shares worth of 50 euros, because you usually do not have a set percentage agreed in the option agreement. Then this regulation is also usually contained in the option agreement. That what happens? Sometimes nothing happens. You will still get 50 euros worth of shares, which now instead of being instead of 2% would be significantly less. However, you can have some sort of adjustment that if the share capital is increased, then the option to be you will be compensated that you have been diluted. It's just because this is something your employee can't control, but this is something to just separately take into account, because quite often even the employee usually, as long as the company has been increasing its share capital and it has been like positive rounds that the company's value has been increased and someone has been willing to invest, usually in real terms, it is still, well, significantly, the employee still benefits, because it's just background economics in mind. But all these details, usually they should be included in the option agreements. And well, everyone who's based in Estonia and have Estonian companies, for you, the good news is that this is not really something you need to worry about, because this is all already regulated in the options agreement. And some of you whom I have had chance to already speak and have some sessions, as I've said, that just that take these agreements, have a go, read them through, and then of course probably something will be a little bit fuzzy, then just reach out to the community and ask to clarify. But at least all these issues have been to extent been thought through and regulated, and in a somewhat balanced way to take into account both employees and employers' point of view. Okay, now we're finally getting to the part why actually, as a potential employee, I would even be willing to accept an option, and why there's even point for you as founders to issue any options. It's exit situation, meaning that actually the shares, once you get you have actual cash, potential coming into account, and one of the scenarios is that the company will be just bought, and that this can actually happen while you haven't really even completed your 3 years time. You still have options, not shares, and there are the different type of regulations that your option agreement can contain. That meaning that you can have a regulation that as long as someone buys the company, automatically your shares will fully vest. Meaning that although it has only been 2 years since you have been employed with the company, someone buys all, instead of 66%, but rather 100% of your shares will be considered vested, and you will get shares. And as the company is being fully bought, you can sell the shares. This is one option, because this is very employee friendly. Usually you mainly see, and from the point of founders, I definitely recommend you to have double trigger acceleration. And this is at least for Estonian template document, you have to make the choice, meaning that it's just not the fact that there will be a purchase of the startup is not the only trigger for accelerating the vesting, but rather the new acquirer must also decide that, okay, and I'm going to let these people also go. It is for the reason that it's up to the acquirer to decide whether they want to keep the people, and for why it's important for you as founders. If you have double trigger acceleration, the potential buyer can keep the employees they want, and hence they are willing to, in reality, pay more money for the company. It's simple economics. And of course, the best is from, I would say, investors' point of view, if there's no acceleration, that the company is bought but doesn't affect the employees at all. Well, this is again problematic. That I would say just a lot of employees might not agree, because if the whole ownership changes, this might have it's a little bit who of you have done the usual salaried work, that if the whole leadership in your company changes, you might want to consider, do I want to keep working there? So it's just comes to reality. But for you, I would say in practice, your employees might be pushing for a single trigger acceleration. You should insist on double trigger acceleration. And if you're going to remember anything from this part of the presentation, it's read those clauses, but double trigger acceleration is your friend as a co-founder and owner of the company. Okay, because now to the second part of what to take into account when considering the use of options, and this is actually the main triggering issue why options are used and why they're popular, is that at least in majority of jurisdictions, the regular salary is highly taxed, but countries around the world and well, in Estonia have created some tax exemptions for employee options. And in reality, this is the reason why options are widely used, because without the tax benefits, the employee companies could either just pay salaries, or they would definitely use significantly less options to motivate employees. And in terms of what to take into account as tax, because I would say from your point of view as founders, the most important aspect I would say that is always, at least for Estonia, but as said in the beginning, it's usually same for other countries as well. It's a 3-year vesting period, because otherwise the company will be open to tax risk, because then it's considered benefit as salary. And if you have probably if you have offered someone options, you have done that because you don't want to pay them that much salary, and just economic calculations won't make sense if the options will be also additionally taxed, for example, with the 20%. In terms of taxation, therefore, it's important to know that all the tax benefits only apply if you have a 3-year vesting period. However, this doesn't mean that it's not possible to have any other situation other than where someone enters into option agreement and has to wait 3 years before anything can really happen. And these are, now going into real life examples that you can have that vesting is done in parts, that you agree that you do want to provide the employee shares just in different steps. That, for example, you want to give the shareholder 2 shares after 2 years, 3 shares after 3 years, and additional 4 shares after 4 years. And you want to give these, for example, for free. Then this 3-year period comes into play. That because the vesting period is less than 3 years, the company has to pay tax, because you didn't really adhere to the tax on those shares that you provided before the passing of 3 years time. So you can do that, but as a founder, it's not recommended, or then you have to have very good reasons, because you significantly increase your tax burden. And this is a cost you shouldn't be doing, but you can do. And the shares that exceed, and which you give at later stage after the passing of 3 years, you don't have that tax obligation. So you do always have the flexibility, but flexibility comes with different tax treatments. Therefore, it makes sense to stick to the thumb rule that you do not give any shares under option agreements after 3 years. One aspect that might be important for you, depending how you want to structure your company, is that the option or the shares can be also provided by the entity's parent company. Because, and very simple terms, you have an Estonian operation company, you're doing well, and you want to have United States investors, and you have a parent company there. Then the parent company can also provide its shares to its Estonian companies or subsidiaries employees. So you have this benefit I would assume for majority of you in Prototron, maybe this is a bit too much into the future, but at least important to keep in mind that you do have, even if you have well, options in the one entity, you do have some flexibility. Of course, think it through how you want to do that, but you do have flexibility. One thing, what is important to keep in mind is that if you have let's keep it simple, employment relationship, standard in Estonian tööleping, then it would seems that but if the company is parent, the company can issue the shares that you can do that. I, as a person, Mirko has employment relationship with the startup, but for tax reasons, I want that the options are given to my personal company, because if I eventually sell the shares, I won't be taxed. And this is what you cannot have, because it has the negative tax treatment. Then you cannot take advantage of these benefits. You, as a startup owner, have to issue these options to at least who are your natural person employees, to them personally. And the employees, they can transfer the shares they have into their own personal holding company for their own purposes. But this is one of the tricky parts to keep in mind, because this is a mistake quite often we have seen been made, is that no, because the employee says, it's not different, doesn't make any difference to you, just I will work for you, but please provide the options to my company. And it has implications for you taxation wise. So it will significantly increase your tax burden, meaning don't do that. So you can provide the options to these natural persons, but you can't at the same when they're employed by you, you cannot separate the person and their company when you're issuing these options, even though the company might be 100% owned by that person, because it is important, because as a company will just have to pay in the end. In terms of the whole circle from the beginning till the end, that okay, let's say we had a company, 3 years have passed, you acquire the shares, and the employee decides to sell the shares. There's some VC fund that wants to buy the shares, some secondary fund. Then if you sell the shares, which have been acquired within 3 years, from a company's point of view, all is good. You don't have, you're not impacted. However, the employee, even though everyone speaks about the tax benefits of options, then at least under Estonian law, the Estonian resident, for example, I, as a natural person, would the whole amount, if I sell the shares, to keep it very, very simple, for 100 euros, then I will be taxed with 20%, meaning that I have to pay 20% tax. So on personal level, options will bring tax consequences at the end if you sell the shares, as you would sell anything else, but the company doesn't have tax burden. What happens if there is full exit, meaning that, let's say, your idea is so great, Microsoft comes and buys your company, then if it happens on the second year, then you will have the beneficial treatment for the 2/3. This is also one agreed rule. At least this is the case in Estonia and in a lot of other jurisdictions. But if you're from jurisdiction other than Estonia, do check with someone locally if this applies. Meaning that the 2/3 of the shares will be considered tax-free, that you will acquire them without them being taxed, and the remaining 1/3, this will be taxed. So this will be applied proportionally, because you, as a, I'll take it in a second, that as an employee, you don't really have control whether the company will be sold in 3 years' time, when you would have the full benefit of the 3 years time period, or prior to that 3-year period. Yes, please.
Thank you. So do you want to say that if employee sell his shares, then he pay tax? And
Yes.
if a company sells or holding, yeah, then they don't pay tax.
This is if I have my shares, I have transferred it to the company under Estonian company and tax rules. This would be the case, because this, for example, in Estonia we don't have companies, company taxation, only on distributed dividends. But this is very specific. In it might differ in different countries, but in Estonian case, yeah, if I have worked for a startup for 3 years, obtained, exercised my shares, transferred these to my personal holding company, and still carry on working, and 2 years' time, the company will be bought, and I have these shares under my personal holding company. I own 100%. Then at that moment, if I sell the shares, I don't have to, yes, pay tax. But of course, if I want to take money out of the company to my personal use, then I have to pay tax. This is from like employee's point of view. But if we have just a simple situation that employee sells its shares, because the company's the startup is not affected by that. It's because it's not a company that's selling, or it's not the startup itself that is selling or buying any shares. Did it answer your question, or you had something?
Yeah, I almost understood. Thank you. Just one more thing. What is the difference between company and holding in this matter?
In this scenario, as a company, I meant the startup, which has issued the options, and which is, so to say, your employer. And as a personal holding company, it's something which you own. It's your own personal company. But it's, yeah. But to keep it simple, one terminology-wise, one would be startup, is where you had the options, and ultimately you had the shares. And at least in Estonia, it is beneficial if you can, so to say, put the shares you have as a natural person into your 100% owned holding company. But this is very Estonia specific aspect, and it's not so clear cut that because if you do that, you put them into the company and sell those shares in 1 month's time, the tax authority will take a totally different view. So, but this is something which is not rule and needs to be looked into. But roughly, these are the Estonian taxation rules related to well, acquiring shares and then later selling them.
Okay, so 30% is the tax in any case for selling shares.
It's just a Estonia specific income tax, but that can easily be changed, and of course in other countries it's different. But in Estonia, the income tax is 20%. Yeah, you would have to pay if you sell the shares.
Okay, thank you so much for answering.
Okay. And one good thing is that but all these rules I have mentioned earlier, they do apply to non-residents as well. For example, if you have a non-resident working for Estonian company, however, local rules that might apply. For example, if you have a German citizen working for Estonian startup, then yes, Estonian startup will insist on 3 years vesting period, all this. However, what are the actual taxes that are applied will also depend on the German rules or Indian rules or, for example, Brazilian rules. So even if you're a non-resident working for an Estonian company, your local rules apply. So for you as startup founders, this is, you could say it's not really your problem how your employees pay your tax, but ultimately, some way, somehow, if they don't have any idea what's the outcome when they actually sell the shares, because they will take their frustration probably up on you, because they have some idea that what these shares should be worth, and this is a good thing to at least mention that if you are providing options to non-residents who are not residing in Estonia, but you have the startup in Estonia, then just mention your employees that there might be some local tax issues, because otherwise they will just find maybe some bad surprises. That is at the moment the end for the options part. And Maris will continue while explaining slightly, because now you at least know how you can maybe motivate people to contribute to your startup, but which type of solutions to use. But before Maris will continue, do you have at this stage some questions related to options? Of course, you can ask later on, and just even if you want, of course, you can just think something through. Maybe you have a specific real life example, and then just later I'll have my email here as well. Just drop me an email if you don't want to ask here, and do you have some more general or specific question, or you just don't want to raise it at the moment?
Thank you for the lection.
So unless, but yeah, I'll still stick around, and as said, if you have any questions, you can later let me know as well. I will pass the floor on to Maris. Okay.
Hello. So I will tell you more about 3 different forms, how to hire or use services of a natural person, and how to distinguish between those 3 types of agreements, because they at first look seem very similar, but they may be very different if we take into account, for example, if you need to, for example, cut costs and get decrease the employment costs, then some may be easier in this regard. So the 3 different forms which we today discuss are employment agreement, authorization agreement, and service agreement. The first one, I think, is the most common one. It's usually a regular job which we do from 9 to 6. The work tasks are determined by the employer. We are under supervision. We are obligated to perform the tasks by ourselves. We receive regular salary, and we have the regular annual holidays stipulated by the law. If there are any risks, the employer then is the bearer of the risks. And this is all something which is regulated by the Employment Contracts Act. and the employment agreement must be written, although here's a tricky part that even if you do not conclude an agreement with an employer, but a person starts to commence work which is to be expected to be on task done under a work agreement or employment agreement, then it is considered that the employment agreement is already concluded from the moment person starts to fulfill his or her tasks. So I suggest to be very clear with your paperwork from the first day when a person comes to the house, unless there will be some misunderstandings. So then very similar agreement is an authorization agreement. But it is a bit different from the tasks and work time perspective. For example, usually the person who provides the services under the authorization agreement, she must not be in your office from 9 to 6. And usually there are more options for him or her to choose the exact tasks which are then needed to be done, because the authorization agreement is more related to provision of a task. For example, on broker, if you tell him or her that please sell my house, then this person shows everybody who is interested from buying your house, the house, but often the broker is free to choose whether to put an advertisement up or to call someone to offer this person your house. So the authorization agreement is more like the person has to then choose the services and tasks by him or herself. However, if a person concludes an authorization agreement with your company, it is expected that usually this person provides the services himself or herself, so that not a third person comes and starts to provide the services. What is also important to note is that this agreement can also be concluded verbally. If you have achieved an agreement with a person that she starts to provide you services, then this agreement does not have to be signed by the parties. If you already achieved a mutual understanding, then the agreement can be concluded. And the under authorization agreement, parties or the service provider does not have to receive regular salary. However, it's presumed that he receives a fee for his or her services. What could be a benefit for you is that under this authorization agreement, you're not obligated to provide the person annual holiday, which means that you do not have to pay for 28 days when the person is on holiday. However, the employment agreement and authorization agreement seem very similar, and the main difference is that whether the person is under a control of the management or not. And unfortunately, if you think that the authorization agreement would be a better opportunity for you, for example, you do not want to give this person a salary, but all the duties this person does and other conditions of your agreement are then similar to the employment agreement, then in case of a dispute, the court may decide that the parties actually concluded an employment agreement. So if you choose that the person you want to order the services for is a mandatory who provides the services under an authorization agreement, then you have to take into account from the first day that this person must be free in choosing the work time, and he has to have like more freedom than a regular employer, a regular employee. Otherwise, this may be actually an employment agreement which has the title of authorization agreement. If we go through the third agreement, this is a service agreement. This is the aim of a service agreement is usually related to the fact that the person must achieve something. For example, the contractor must make me a new table or write you a very specific part of one code. So this is something which is the contractor has to achieve something. So this is not related to everyday services. And similarly to the authorization agreement, you do not have to enable the contractor a holiday. Usually also the agreements concluded with contractors are related to a specific task, so they aren't agreements which are from year to year. So usually there would be also any need to provide service holiday to this person. Similarly, the contractor must be free in choosing the workplace and work time. The service agreement and authorization agreement are both stipulated in the Law of Obligations Act, and the main conditions of those relationships come from there. So, and you can conclude a service agreement also verbally. So these were the main mandatory requirements of the three types of agreements. Which I also would like to point out is that, for example, in case of you need to terminate any of those relationships, then the employment agreement is something that it is stipulated by the law when you can terminate an employment relationship. Usually it's quite hard. You have to have a reason for it. A layoff would also be a reason, but there are some conditions. For example, if the person has a child who is under 3 years old, then this person has a preemptive right to keep his or her job. Then if they have the same level, you have, for example, 3 IT workers, then you have to choose this one who has this child under years of 3, and you can only choose whether you want to then lay off any of those other persons. So this would be a bit tricky. In case of authorization and service agreement, you're free to determine in the agreement that, for example, you can terminate the agreement by a notice, which is submitted 30 days in advance. So it gives more freedom to the parties. So the next part is about the yeah.
Sorry for interrupting.
Yes.
In what job titles, yeah, they like allowed to take to offer like authorization agreement, or yeah, I haven't faced this case with authorization. In which cases?
Oh, this is something I would say, for example, if an accountant is not providing you regular services, for example, but he's doing only few hours, then this could be an authorization agreement. Or, for example, if a person is hired only for a very, very specific project, then this is not related to the title, but more what this person provides.
And is it different from freelance?
No, I would say that this could be a freelance also.
Okay, thank you.
So now I will talk a bit more what could you additionally agree, taking into account these 3 types of agreements. Because in case of employment agreements, it is very strictly stipulated in the law what you can agree. For example, you can only agree those contractual penalties which are stipulated in the law, and there are only 3 types of contractual penalties there. So you cannot choose additional contractual penalties in case of employment. So if we start with the employment agreement, then you can agree that a person must maintain the confidential information she receives during the employment relationship. And in addition, you can agree that the person must pay the company a contractual penalty in case the person breaches this obligation. However, the term confidential information and what exact information this exactly includes must be stipulated in the employment contract very clearly. We also usually suggest the companies to stipulate a contractual penalty for the breaches of confidential information, because for the employer, it's very hard to prove the damage which the employee has caused with the breach if the person has published the confidential information. So if you cannot prove what the damages were, you may be in a situation where it is very, very hard to claim any damages from the employee. However, if you have agreed in a contractual penalty, it is easier for you because you do not have to prove the damages, you only have to prove the breach. So this is easier. However, the contractual penalty, the amount shall be reasonable. If it's not reasonable, the court can decrease it. Then you can agree that an employee may not compete with the company. There are 2 types of non-competition obligations. One is which is valid during the employment relationship. This is something that the employer must not pay any additional compensation. For example, if the employer wants that the employee will not compete with the employer after the termination of the employment relationship, the employer must pay for the employee compensation. There is not stipulated in the law which would be the amount of compensation. However, usually the courts have been on the opinion that the compensation which is less than 50% of the employee's previous salary is a too low compensation, and the employee is free to compete with the employer. And you can also agree that in case the employee breaches the obligation to compete, not to compete, you can demand a contractual penalty from him or her. As also in case of confidentiality, we suggest to stipulate on a contractual penalty for such breach. Starting from August this year, there is a change in the law, and if you do not agree in the employment contract, then the employee cannot compete with your company. Then the employee is, during the time she works for you, also free to work for your competitor. So this is something to keep in mind if you start drafting the agreements. So for example, if you forget to include this clause, it may mean that after working time, she provides services for your direct competitor. Then the intellectual property rights are assigned in some aspects already under the law in case of employment agreement, but we highly recommend to specify this agreement in the employment agreement. Then if the employee does not start working, but you have already concluded an employment contract, which includes a penalty for not starting to work for you, then you can also demand this compensation. This is usually in the amount of 1 month remuneration. And these were actually all restrictive agreements which you can agree in an employment agreement, because as I mentioned, this is very specific, because the laws are very in favor of the employee, and everything is considered in favor of the employee. In case of the authorization and service agreement, you have a lot of more freedom. And as you can see, this table here says for all the agreements which we already discussed, that you can agree all of them. You can agree with a service provider that she must maintain confidentiality, may not compete, she must transfer or intellectual property rights for your company or give you a license for that. If they do not start providing services for you, or they will terminate earlier, you can agree that they must pay you a compensation because you have to find a new service provider. And if you have any other agreements which you would like to agree with them, then usually it is allowed. What is also different in comparison to the employment agreement is that if in case of employment agreements, the maximum periods a non-competition can be valid after the termination of the employment agreement is 1 year. Then in case of authorization and service agreements, the maximum period for non-competition is not stipulated. However, this shall be reasonable, not forever. And in addition, you are not obligated to pay for the service provider compensation for adhering this this obligation. So as said, these two types of contracts give you a bit more freedom to agree how you can or how you want to agree. So this would be all from my side. We are now willing to answer the questions if you have any. Mirko is also next to me still, so.
What resources could I read, to learn more about this agreement type?
It's a good question. Regarding employment agreements, we have one website which is maintained by the Labor Inspectorate. There may be also written something how to distinguish between those agreements.
But yeah, there's no, so to say, in-depth overview of this, because this is something we have put together, because for a very simple reason that it seems something that we were specifically lacking for startups. So the unfortunate part is that I think there's not really good, very general area, other than I would recommend, which would achieve similar aim, is that 3 examples of these documents are provided on Startup Estonia's website, because from there you can see a typical employment agreement, you can see template service agreement, unless this is actually, I think a few days ago it was in maintenance, and there's also a management board agreement, which is the classical authorization agreement. So you can, because those are 3 distinct types of these agreements, and then they might be helpful to understand what was meant. Yeah.
Okay, thank you.
Yes, Aimar.
Yes, I lower my hand now. Okay, I have a question for you, Mirko, regarding these options. So the first one is that the option pool is stated in the founders agreement, but in case there is additional need to, additional option package, how it is agreed? Should you amend this founders agreement?
Yeah.
Or how it is?
It's
Okay.
especially it's very vital in cases when the company doesn't also have sufficient, doesn't have its own shares, treasury shares, for example, that you can already give, because quite often, as this is something you would do in the future, but unless you have amended that in the founders agreement, I would say that in the old agreement, let's say me and Maris have agreed to do something, and now Maris, as the CEO of the company, promised something to you that, yeah, we will issue new shares. But unless it's in the founders agreement, I will later say just no, because it will dilute me and my shareholding. And unless there's a written part, I'm actually not obligated to do that. And then there will be a problem that, as I said, that from your point of view, you don't really care how we come up with those shares. But now internally, that there would be an issue with that. I have signed a certain commitment in the beginning, but if you don't have it amended, then yeah, at the time when there is this actual share capital increase, and I as a shareholder need to say that, yes, let's increase the share capital because my signature or vote is needed, then I could say that, but why should I? Because I haven't taken the commitment, and hence.
So sorry?
Yeah, and that if I haven't taken the commitment, meaning that it's not in the written founders agreement, yeah, Maris can say that, but we promised, I'm going to say that, show me the amended founders agreement that I agreed that we will have 5% option pool. You can say that we agreed on 10 or 15, but unless it's the new agreement is in a written form, because it amongst co-founders, it shouldn't become an issue, but still, the more shareholders you have, at one point you don't even have founders agreement, then you have shareholders agreement,
Yeah.
which founders will be parties to, because the more parties you have, as if you agree if you promise to do something in like even 1 year's time or 2 years time or 3 years time, better to have that, as long as everyone agrees to have it in written form, because already in maybe half a year, people's memories might disappear because it might not be in their interest. Hence, the moment you amend, it applies to other aspects as well related to, for example, the founders agreement, but specifically for options, because in certain cases, you cannot increase the share capital without all or majority of the existing shareholders.
Okay, so that was the issue that in case we now step into the shareholder agreements after the issuance of new shares, then we have to agree with new shareholders, the new terms of the options and the pool. All right.
Yeah.
There is now one question: are these options sellable? How we can we sell them?
Yeah, it's. I would say majority of the companies don't even allow them to be sold. It's because for the simple reason that as this is part of motivation, for example, because let's say you have a startup and I'm employed, I will have my options, but I will keep working. And at the moment, I think your startup is going to make a lot of money. So I'm going to sell these to Maris. I will get my cash out. You haven't made an exit, but I have made a cash out to Maris. The chances that I will show up in your office by 9 or even 10, rather I will pop by at 11 and first have half an hour coffee break. So it's for that simple reason, you don't want me to be able to cash out, because this is me being able to sell my options is a way for me to do, so to say, mini exit. But if others, plus if other employees cannot do that, they will be extremely pissed at me and at you as well, because you provided me a special treatment. But main part is that you want to ensure that if there's a big payday, it's when everyone has a big payday. Yeah, you can have exemptions. You can rather you want to have this option that you can, well, as a majority shareholder, you can always treat someone better. For example, it's easy to say that if someone is a bad leaver, that the joins even competitor, you can always decide, shareholders to think that, okay, this is not just morally right. That, for example, Mirko was the key employee, and yeah, he joins a competitor. You can always treat me better than what's agreed. You can't treat me worse than has been agreed. So rather, if you want to provide the ability to sell my options, then don't agree upfront. Rather, make it that I have to come to you and reach an agreement to do that, because this way you also have more control and you ensure that I'm actually motivated to work for the company.
Clear. And the last one, do these options also, you can write in that they do expire if you don't exercise them.
This is actually the standard part, because after 3 years, you have 2-3 months time period to do something. So the worst thing as an employee you could do is you stay there for 3 years and, well, you forget to exercise. But in reality, because this doesn't happen in practice for the reasons that either it's so financially beneficial for you to do, even if you don't have the funds, you will borrow them, or it doesn't have any value, and then you can easily do that. You would say that I just don't care because I'm not even going to pay 50 euros for something which is actually worth maybe only 5 euros. Of course, if it bumps up again, you're probably going to hate yourself for the rest of your life. But well, but you do usually have like few months time frame, and for the very reason that you, as a company or as a co-founder, you don't want this lingering situation where you don't know who are going to be my shareholders, because at one point he said, are you in or out? And it serves the main purpose of having clarity. Who are the shareholders of the company?
Okay, thank you. All clear. Thank you, Mirko.
Does anyone else have any questions? Or if not, then yeah, feel free to drop us an email or reach out via LinkedIn and just ask these so to say offline. But I think at the moment we do not have any additional questions. So I will stop them recording this. Let's see. Yeah, stop record. Okay.